So we know that, well, we're told that what happens in Las Vegas stays in Las Vegas. But that's not true with law schools. What happens with law schools spills over into the profession. So the issues that we've been talking about free speech and civility, we have to also think about in terms of the profession. And of course, there clearly are exogenous drivers, the culture, so to speak, the culture wars. But we're delighted that we had such a powerful panel to discuss the influence or the issues of free speech and civility and how it's changed the profession, and some solutions as well, we hope. Unfortunately, our planned moderator, Sean Snyder, the president-elect of the D.C. Bar Association, had the temerity to get ill, but he was gracious enough not to want to inflict his coughing on us, so he's withdrawn, and we managed to get my colleague Bob Destro to moderate the panel. Bob's been a member of our faculty here since 1982. He was interim dean from 1999 to 2001. He served most recently as Assistant Secretary of State for Democracy, Human Rights, and Labor at the State Department, and he led the department's worldwide effort on human rights and democracy, including free and fair elections, internet freedom, the growth of the surveillance state, and religious freedom. He's, as he always tells me, just a labor lawyer, but he does much more than that. He's become one of the main advisors to churches and religious and organizations on a variety of legal issues related to religious liberty, both here and abroad. So we're delighted that he is serving as moderator. Now, as to the speakers, Paul Clement, everyone knows him, the 43rd Solicitor General, and before that, acting Solicitor General and Principal Deputy Solicitor General. He's argued over 100 cases before the Supreme Court. He's a founding partner of the D.C. law firm of Clement and Murphy. He has to leave for another commitment, so he may not be available for the Q&A. If he's available for a little of the Q&A, jump in on him first. Lisa Blatt, Chair of Williams and Connolly Supreme Court and Appellate Practice. She's argued 46 cases with the Supreme Court, but I think she's in a rapid pace to catch up. She's considered by the National Law Journal one of the most 100 influential lawyers in America. Bloomberg has described her as legendary, and the National Law Journal has referred to her as a SCOTUS legend. I won't go further. So we're happy that she can, and she has 2 children in law school, so she has a personal stake in what's going on. Our third panelist is the Honorable Kyle Duncan on the Fifth Circuit Court of Appeals. He was a partner in the D.C. firm of Shore Duncan and previously Assistant Solicitor General in the Office of Solicitor General in Texas. He's taught at the University of Mississippi Law School and Columbia Law School. He was General Counsel of the Becket Fund for Religious Liberty, where he managed the Beckett's nationwide public interest litigation. Now, we've talked about him as in terms of what happened to him in Stanford. His focus now is not on his own personal story, but on how we can deal with solutions in the profession. So thank you. I'll turn it over to Bob.
Well, thank you, Marshall. Thanks, Marshall. And what I'd like to do is see if we can have a little bit of a discursive panel instead of everybody giving long comments. But I wanted to frame the comment a little bit in terms of one of the courses that I teach periodically is legal ethics. And so when we talk about lawyers and clients, I mean, that's the profession. Somebody who doesn't have a client isn't really a lawyer. They're a person with legal training. But as soon as you get that first client, then your entire universe is bounded by obligation. And the rules basically set out what those obligations are, but I think one of the best short versions of obligation was given by the late Robert Cover of Yale, who spoke here many years ago now, and he gave a paper called Obligation, a Jewish Jurisprudence of the Social Order, where he talked about, and I quote, "A right without an obligation is a sad, almost a pathetic thing." I put that in the context of what are we doing when we're actually practicing law? And it strikes me that we've been through the general right to free speech, we've been through the university setting, we've been through the law school, and now we've got the gatekeeper function of the courts. So now the question is, what do the courts, what does the bar, what's our obligation to make sure that at least that controlled environment, the courtroom, is open to the kinds of both advising and speaking that we need to look at. And so what I'd like to start out with is the gatekeeper function of firms. What kinds of kind of safe thinking, kind of cancel culture issues, if any, have you seen in your respective firms? I know that Paul Clement has had some issues with having, inhospitable kind of, we talk about hostile environments all the time. There was a hostile environment, at least in one of the firms, with respect to some of the clients. So let's start out with the gatekeeper function in the firm. I mean, how have you seen that? Let me start with Paul Clement.
So thanks. I'm happy to start, and it's nice to be asked to join a panel, not because I've argued 100 Supreme Court cases, but because I can't keep a job. So this is really cathartic. What has happened to me actually twice now is that after representations have been undertaken, my law firms, big national law firms, have decided that continued representation of that client is not in the firm's best business interest. And so as a result, they've given me essentially an ultimatum that you can either, drop the client or you can leave the firm. In fact, the first time I was just told to drop the client, I actually don't think it occurred to the firm that I might just decamp to another smaller firm, because I was coming right out of the government, hadn't made a lot of money during my government service years. They were paying me a lot of money, so they just assumed I would do what they told me, like most of the, frankly, other lawyers in the firm. But I viewed it as an ultimatum to drop the client or to leave the firm, and left the firm. And then the same thing happened to me roughly 11 years earlier. I guess, though, what I would say is, maybe you can, just the differences between the two situations maybe demonstrate how much worse things have gotten in the last decade. Because the first time, it was over the representation of the House of Representatives defending the constitutionality of the Defense of Marriage Act. And I think we all understand that there are certain issues that are particularly controversial. And that's one of those issues that has historically been pretty controversial. And it also was at the early stages of the representation. I'd just been representing the House of Representatives for about a week. It's still, at the end of the day, the principle didn't seem any different to me in the two situations. But fast forward 11 years, and I'm given this ultimatum after we've been representing the same client for over 5 years, and after my law firm had been happily cashing their checks for over 5 years, because this is not a pro bono representation. This is a full freight paid representation. And after 5 years of that, of cashing the checks, after the Supreme Court rules in favor of my clients 6-3, I'm told I have to drop that client, and I have to drop them immediately, even before the proceedings on remand after their Supreme Court victory, or leave the firm. Now, the second time around, it was, they watched my experience, they could probably pull off the internet my King and Spalding resignation letter. So they knew it was essentially an ultimatum, and they probably even knew that I wasn't going to, change my mind 11 years later in a more egregious situation. But if you take a step back and just take the specific issue off the table for a second, it was a Second Amendment issue, and we'll get back to that. But if you take that issue off the table for a second, the idea that a law firm, after one of its partners had just vindicated the constitutional rights of two citizens in a Section 1983 suit against a government that had deprived them of their constitutional rights, that under those circumstances, they would not have a victory celebration in the library, but they would actually tell the lawyer to take those citizens and their constitutional rights and essentially leave the building, is, to me, borderline unfathomable. And, okay, it was the Second Amendment. So what does that tell you? That tells you that we've moved from a universe where it was maybe abortion and sexual orientation were like the two third rails that you couldn't touch. And now the number of third rails is multiplying to the point where there's a whole host of issues where lawyers really can't touch at the biggest law firms. And I have to say, it's not actually that you can't touch them, you just can't touch them if you approach them from the right. If you approach those same issues from the left, there's really no problem whatsoever. And if you look at amicus briefs that are filed in controversial cases involving issues like abortion, all the big law briefs are on one side and none of them are on the other side. So the problem, in my view, has gotten materially worse. And just the last thing I'll say, and then we promise no long soliloquies, but one last thing, is what makes this, I think, particularly troubling is for a law firm to do this after the Supreme Court has ruled favorably for the clients that the firm had represented. At that point, it's a shot not just at the clients and not just at the lawyer, but it is a shot at the Supreme Court of the United States and the 6 justices in the majority who issued that opinion. And so if we've gotten to the point where one of the most sort of largest and sort of generally well-respected law firms in the country is willing to do something like that, I think we are in a much worse place than we were in 2011 when I first went through this.
Thank you. Lisa, let me ask you, in terms of the kind of what I've called the gatekeeper function. I mean, how do you see the dynamics inside the firm? You don't have to speak. You can obviously speak and say whatever you want in terms of your own firm, but how do you see the dynamic that leads to something like what Paul described?
Yeah, I have to say, I don't know what you mean by gatekeeping. So I do think the problem comes from, law schools and young people. I don't understand why a lot of these people are in law school or go to law firms. A law firm exists for one purpose and one purpose only, and that is to serve clients and win for them. And if you're a law student coming to a law firm with lots of agendas, don't expect to do well and collect the check, especially you're coming just to earn money, but then you need to realize your only purpose in being a lawyer is to represent a client. If it's to change the world, run for office or start a public interest firm or go straight to a public interest firm. But you should check your politics at the door when you enter a law firm. It's about the client, it's about winning. And I do think it comes from young people, not people over 50, that you're being judged for your clients. When the criticism about Paul had come out, was not particularly even friendly with Paul. I remember publicly stating, I don't understand the criticism. These people who are criticizing him hail the people who were representing the terrorists from 9/11. Like, that was a public good to represent a terrorist. It's a public good to represent a capital murderer who's confessed to murdering someone. That's a good thing. But to represent a bill that was signed by President Clinton made Paul a pariah was absolutely preposterous. And then I think Paul and I became friends after that. But I don't even think people check their common sense at the door. I do have people who criticize me all the time for my clients, and that's fine. I love my clients, and that may explain a reason why I tend to win. And you should love your client. If you want to be a good lawyer, I get called a mercenary. I literally went to law school not to change the world, but to help, one person. And I just think the ethics of the profession now are not about, unless, you go to a law firm actually to represent clients, it's about you putting your own personal opinion on top of other people who have a right to hire counsel. It's really disturbing, and you will be a bad lawyer.
Well, that was actually what I meant when I said gatekeeper. Either, when I took legal ethics, we always were told you're supposed to represent unpopular people because they have a right to representation too. And I think that's what you're saying.
But the problem with teaching legal ethics, and again, I have these 2 kids in law school, ethics is taught as like, oh, this is a rule book you need to comply with. And it is complicated. Someone who has to turn to ethical questions with conflicts, with joint representation, there's lots and lots of really nitty gritty you have to come in. But the underlying reason, why did I go to law school? What am I here learning? Why am I studying these disciplinary? What am I doing here? Do I care about my grades? Do I want to clerk? People now cancel people because of their clerkships. The whole judiciary has become divided in clerking. Why do these people feel so self-entitled to judge other people who disagree? Like, nobody can recognize that they might be wrong on an issue, which is just astounding. Paul and I have very strong views on opposite ends of the spectrum, and I actually think Paul and I can talk about abortion or guns in a very fun and healthy way. I'm usually right, he's wrong, but I guarantee Paul wins the debate every time. He will out-debate me, out-lawyer me, and I'll end up having to say, okay, fine, you're right.
And I want to give the judge a chance to talk, but he's been out of the profession for a little bit now. I would just say there's one, so I think Lisa's right that part of the problem is coming from some of the, the law schools, and the problem is sort of spreading. And, as to that piece of it, I think that the law firms really have an obligation to, essentially tell them, check that at the door, as Lisa says, and you're in a different place now. And whatever's going on at law school, here we're representing clients and really instill them that sense in them. But I think there's another countervailing pressure that I think explains maybe why some of the law firms don't do a good job with this. And I think it varies from law firms to law firms. But the short of it is, the big national law firms have just gotten way too profitable for their own good and for professional ethics. And if you look at, I'm pretty sure you could get a pretty nice chart out of some American lawyer publication that shows the profits per partner at like the top 50 firms over the past 15 or 20 years. And it is a line like this, and you now have this thing, there's an article in the Wall Street Journal not that long ago, that in many instances, the lawyers are making more than the bankers on some of these transactional areas. And that's really not particularly sustainable with a true dedication to the ethics of the legal profession. And the part of the problem that's going on in the legal profession right now is that the biggest firms, the pressure to up that profits per partner so you can steal laterals from the other firms, and that's kind of the currency of the realm. And that drives the practice of law at the highest earning firms and the highest profile firms more towards transactional work. And one of the things I've learned over the years is that it's a funny thing about transactional lawyers, they tend to be transactional. They don't sit there and think, what are my deepest legal obligations? And they don't really have a deep-seated commitment to the idea that lawyers represent unpopular clients. Because in most transactions, it's two relatively popular business entities that are going to merge or 3 years later unmerge. And the one thing that unites both of them is that afterwards there'll be a victory party, and nobody's representing a murderer, nobody is representing somebody who has been accused of poisoning the water supply in a small town. Nobody is even representing somebody who's really been wronged by our legal system and needs to fight really hard to vindicate their legal rights. They're just representing banks and banks and more banks, and they don't really have the same dedication to these principles. And I think there is a divide between the litigators, who I think still get it. They still get it that if you're really popular with everyone, you don't get sued, and you don't need a litigator. So there's still this basic understanding about the basic bedrocks of the legal profession. But I don't think some of the transactional lawyers have that just baked into their thinking about the profession of the law in the same way, and they are very focused, and I would say way too focused, on the bottom line to be a true profession.
Now, that's a very interesting perspective. And I wanted to,
I'll give you two.
Okay. Yeah, sorry. No, keep going.
No, what I was gonna suggest, but it's the judges who are the ultimate gatekeepers to the profession. You're the ones who disbar people, you're the ones who discipline people, you're the ones who control your courtroom. I mean, do you see this coming up in the August, reaches of your chambers?
So thanks, Bob. It's wonderful being on the panel with Lisa and Paul. I usually moderate a panel with Lisa and Paul, so I don't have to do much talking, which turns out to be perfect because they. But now, so yeah, I have a different role than they do, obviously. So now, thanks to the political process, I get to sit on a bench in a robe and decide cases, which is fun. So I've been on the bench 6 years, and now my view, I guess, I get to be now the one who delivers the good news, because I see what's going on. I have nothing to say back to what Lisa and Paul are saying. However, I do have the good news is that I don't see this impacting the work of the federal judiciary at all yet. And that is good news, because we judges, obviously, especially the recent ones, we go through this awful political process of confirmation, which is by definition and by some necessity politicized. But we step through that, and we step into a realm that's really quite surprisingly collegial, where judges from very different perspectives and different eras and different political parties who are put on the court by different presidents actually have to talk to each other and listen to each other and arrive at some kind of consensus about cases, and some of the cases are very difficult. And yet we have to do that because that's our job. And so the message that I'm bringing to law schools, and I've obviously had an experience with cancel culture, is that cancel culture does not work in the court system. And that the reason should be obvious. This is what I tried to tell those kids at Stanford. They wouldn't let me get a word in edgewise. But I was trying to tell them that yelling at people and shouting down people and not listening to people because of their political background or the color of their skin or their perceived religious commitments doesn't work in a court of law. In a court of law, two people come in and there may be billions of dollars at stake, or there may be some incredibly important constitutional principle at stake that touches all of the many third rails in our public life. And yet, one lawyer stands up and gives reasons for his or her position, representing her client. The other lawyer gets up, gives reasons. We judges, we ask questions, and the questions are based on what the statute says, what the Constitution says, what the briefs say. And this is not just window dressing. This is actually what we do. We like for both lawyers on both sides of the question to be good advocates. Otherwise, it's harder for us to do our jobs. None of this process that I'm describing is remotely compatible with what I perceive to be cancel culture that's going on in universities or law schools or law firms or corporations. None of it. When I go back to conference with my colleagues, we do not yell at each other, right? We do not say, well, your cis heteropatriarchal privilege is speaking today. It's a challenge that I've given my clerks to use that term in an opinion, and nobody has risen to the challenge yet. That's because they can't spell it, and it's a made-up word, and they don't know what it means. That is not how I sit on panels with judges who were put on the court by President Obama or President Reagan or President not Ford, but Carter. Okay, I regularly sit with Judge Carolyn King, who was put on the court by Jimmy Carter, right? And we get along great, and we often agree on very important constitutional issues. I sit on a court with Judge Steve Higginson, who was put on the court by Obama, who is brilliant, who is super prepared for oral arguments. And if I want to disagree with Steve, Judge Higginson, if I want to disagree with Judge Higginson, I'm not going to say, well, you're an Obama judge. Of course you would say that. Of course not, right? That would be rude, and it would be foolish, and it would be counterproductive. Instead, I have to actually engage with what he says, with the reasons that he gives. So all of this to say, I don't see it yet. Sort of this, if this is a river and it starts wherever, in kindergarten, is that when cancel culture starts? It starts in kindergarten and it rises up through the undergraduate and then into law schools and then is now, it sounds like, firmly ensconced in big law firms, at least with a lot of banking clients. So far, the polluted river has not reached, in my view, the federal judiciary. It doesn't impact what I do, how I think, on a day-to-day basis, and I'm glad about that. I don't miss all of that stuff. I represented clients in very controversial cases, and I was glad to do it. I didn't always agree with my clients. It didn't really matter because they deserved good representation, and I was firmly committed to the idea that the system worked best if you had good lawyers on both sides, and I tried my best to be the good lawyer on that side. I'm not seeing that so far in the federal judiciary, and that's a good thing. But, and we'll talk about this later, one must be vigilant. The Article 3 is full of humans, I'm afraid. And humans tend to be fallible, and they tend to they tend to love their own views, and they tend to overstep their responsibilities. This is why we have separated powers. This is why I'm very grateful to be on a panel of 3 in my court, so they can check me when I want to do something truly outrageous. And yet we have to be vigilant. And so, for example, so I guess the way I look at it is Article 3 is cancel culture insurance, right? Nobody can cancel federal judges, and it's just it's a great privilege to coin a phrase, right? It is a privilege not to really have to worry about what some law student thinks of me, or what some op-ed writer thinks of me, or what they say to me on whatever they're calling Twitter these days. But part of the bargain is we don't get to wave flags as judges. We don't wave flags, whatever the flag might be. We don't wave them, right? We don't do politics. I don't go around making speeches. Contrary to what you may have heard, I don't go around making political speeches. I talk about boring law stuff. So that's part of the bargain. And as long as we keep that bargain, and frankly, I think the judges that I serve with, and you can read what they say about the Fifth Circuit. I know what they say about the Fifth Circuit. And yet we judges in the Fifth Circuit, we decide cases. We get along well with each other. I think my colleagues even might like me a little bit. So that's good news from my perspective. But listening to these folks and seeing what goes on at law schools, am I optimistic for the future? I don't know. It seems it will test our ability to keep up this bargain. And I sure hope we do, because goodness gracious, if we don't, I mean, why would we have courts to begin with if they're nothing more than sort of political bodies? I don't know.
Well, let me raise the question. You and I talked about this briefly beforehand, and I certainly saw this during my government service, is you have a lot of pressure from the staff, to make statements. We've seen now, at least in one confirmation hearing, and then just today I got some information from within the federal government about, a judicial candidate. The Michigan Supreme Court, for example, says you have to announce your pronouns, when you stand up. What does that do, especially in light of President Enix Ross's comment about 52% of the people might not trust the judiciary anymore? How do judges particularly deal with that? And then for our other panelists, how do lawyers help the judges keep that free space?
Well, I mean, I feel I can speak to this because I'm on record. I've written an opinion saying I don't think federal judges have the authority to force people to use people's preferred pronouns. I've written that. You can disagree with it or you can agree with it, but I wrote it. It's a published opinion of our court, and I give reasons for it. Some people don't like that. Now I have heard that at least one state Supreme Court is going the other direction and mandating a different rule. And without getting into the sort of the specifics of it, I mean, the rule names my opinion as ostensibly wrong. I think this is an example of judges getting into contested questions, and it risks the impartiality of the judiciary. When a lawyer appears before me, every single judge I know is respectful of the lawyer. Now, sometimes the arguments get heated. Sometimes I get annoyed at the lawyers. I know they get annoyed at me, but we're respectful to each other. But the moment you get into the issue of controlling people's language, whether it's judges or lawyers or clients or whoever, when you get into that sort of intimate realm of you must use this word, you may not use this word, it's a problem, in my opinion. Others may disagree, but I think getting into those issues is a really bad idea. And I think that I take the view that you can, look, as long as you don't, call me a four-letter word in court, you can call me whatever you want. I'm going to call you counsel, right? We're going to have a debate about things. But don't get into, if you use this word, then you've done this thing. You've microaggressed this or you've done that. I think this is just a bad idea. No matter which side does it. I know that one side, frankly, of the debate tends to be enamored of this idea, but that doesn't mean that in 5 years the other side might not be. I think this is a bad idea, this forcing specific kinds of language. Just my opinion.
Well, Lisa pointed out that she thinks that law students should leave their attitudes at the door, but they're in the door. And so now the question becomes, how do practicing lawyers who actually argue cases for their clients help judges like Kyle to keep the courts a safe space for robust speech? Because you have to be, you have to be open about it. You have to be able to argue your case.
I mean, you're talking to someone who put an appendix in the Supreme Court that was like 70 pages of porn. So I don't see the courtroom as a safe space.
Well, I think the point is that, the courtroom, while not a safe space, is a space that is not yet infected by this sort of culture. And, as the judge kind of eloquently puts it, it's kind of unthinkable that it could, because if it ever did, it would become something other than a court of law. You just go in there and say, how dare my opposing counsel even take that position? I'm done here. I'm not talking to that person again. They're beyond the pale.
That'd be fine. That would give back a lot of time to us.
It would, but if that kind of argumentation could be successful, then I think we'd be just about done with the Article 3 project. So I guess what I think about this issue is, and this is what sort of saddens me a little bit about some of the trends I see in the law firms, is I see there's two things where the bar has a special responsibility. One is to explain to non-lawyers how it is that a lawyer can represent somebody who is accused of murder and in the views of the community almost certainly did it. Or how in a case where, like, let's take, a modern sort of situation like opioids, like how could you possibly represent a manufacturer of opioids or a distributor of opioids? I think lawyers have a special responsibility to explain to the general public who are non-lawyers why that's okay, and not just okay, but affirmatively good and something that our adversarial system of justice depends on it. I don't fault for a second a non-lawyer for not getting that. I think non-lawyers, before I went to law school, my instinctive reaction would have been, you are who you represent. My mom said something like that when I was growing up. You are what you eat, right? So it doesn't come naturally to people. But after 3 years of law school, you're supposed to come out and you're supposed to robustly defend this whole idea that don't judge a lawyer for his or her client, and understand that it's absolutely essential that both sides have excellent representations. That's the first responsibility. But then the second responsibility the bar has is to explain and, dare I say it, defend judges. and explain what they're doing. Because if they dismiss some very attractive case with some sympathetic facts on some jurisdictional grounds, the lay public isn't going to understand that any better than representing the axe murderer. But it's important to our system that jurisdictional rules stick and that judges, even if you disagree with the judicial decision, it's important to model the right way to criticize the decision at the same time that you underscore that judges are entitled to, indeed must make difficult decisions, and there's an appellate process, so maybe this decision you don't think is right is the last word. But lawyers have a special responsibility, essentially, to defend the court system and explain what the judge's role is. And when law firms effectively criticize the Supreme Court and decisions of the Supreme Court as being, so problematic that they no longer want to be associated with the client who just prevailed in the Supreme Court, that sends exactly the wrong message to the general public. So I would say we have a responsibility to try to keep the court system as a place where cancel culture can't get in there, and to keep the court system strong. But you can't really do that if you're essentially on record as saying, the current court just, isn't a very good court and they keep on doing awful things. I mean, that's just not, you can't pull that off. I don't think you can have it both ways.
Yeah, and I'll just say, again, this is from being so close to Paul and teaching with him. Whenever I'm whining or trying to be critical, he always said, Paul just reminds me, why don't you come up with an affirmative case or come up with a story instead of just criticizing? Like, try to figure out what the positive way to try to spin this. I will say that it's not complicated on what Judge Duncan said and Paul said. If you are a judgy lawyer, you don't check your politics at the door, you will fail. You will be a bad advocate, a bad lawyer, no one will hire you, and you will never get in front of the Fifth Circuit to insult Judge Duncan. Nobody wants to hear from you. Paul is the greatest advocate living, and probably will ever live. Paul doesn't judge his clients. He's represented all kinds, on the left, on the right, in the middle, upside down. He just litigates, and he wants to tell the story. And the other thing I try to tell law students, and I don't know if it's getting through, is heaven forbid their father gets indicted or someone tries to take away their child. Do you really want a lawyer to say, this was kind of your fault, and maybe you should have, not have said that, or in a divorce, or someone tries to take away your house? Lawyers, and I'll even put this, at least judges should be right up there with clergy, nurses, and teachers. They are doing a public service. Their job is virtually impossible because, as you said, there's only good news. You frankly deliver bad news to half the people that appear before you. What a nightmare to have to be a judge. And I do think it is downright despicable of people to judge other law students based on for whom they're clerking for. And so for those of you law students who do it, have fun now. You're peaking. It's only going downhill from here. Was that too rough?
No.
Well, what about but it raises the question, you put it very well at the very beginning when you talked about there's a difference in kind of the age culture, the younger persons versus the older ones. How possible is it, for firms to actually engage in that kind of diversity, equity, and inclusion training? Because we know a lot of firms have it, but do they have First Amendment training? And do they have that basic legal education? What about the unpopular client? What about the guy in Guantanamo?
Well, yeah, so, Williams and Connolly were all litigation. I think they represented Jimmy Hoffa at one point. Williams and Connolly is a very different kind of firm where it's not very political. I was at another firm that consistently and only would represent anti-guns. They were just, and anti-death penalty. Definitely they were proud of their liberal bent. That was part of the culture. It was a very different place. No one came to work the day President Trump was elected. So it was just a different type of environment. Some firms are proud of that. I do think firms lean left. I do think it's different when you do start introducing practice groups outside litigation, and maybe that's the difference. If you want to be a food and drug lawyer or a tax lawyer, those are also very removed from politics. I do think it's okay to be political. It's okay to join political groups and be at a law firm. It's okay to advocate. It's okay to, want to run for public office. You can have politics, but it doesn't work in a law firm if you're judging people or and at the same time, I do feel that law students feel very aggrieved. They feel the world is unfair, probably because it is. And the Supreme Court is issuing decisions that are very disruptive to people's lives. I'm very sensitive to that. I think some of the decisions are tragic. But we still have to figure out what is going to be productive to do at this point as opposed to attacking people, which is not going to help.
I think I vividly remember in law school, and I didn't go to a very good law school, but I vividly remember perceiving from day one that this is I wasn't a law person. I didn't have lawyers in my family. And I remember perceiving, this is a skill that they're trying to teach me. It's an advocacy skill. It's a rhetorical skill. It's an advocacy skill. They want me to train me to do something. And that is to represent someone who has a problem and they need it solved. And you have to follow these rules if you want it solved. And I wasn't a very political person. I could tell that people around me had all sorts of political ideas, but I thought, well, we're here to learn a skill. And I remember thinking, I've got to be detached somewhat if I'm going to do this job properly. I can't be grinding an axe in every single case. Otherwise, I could take my law degree and maybe run for Congress, or run for Senate, or do something else, run for school board, run with my law degree. But being a lawyer, there's a specific skill set involved, and detachment was always it's like, okay, I have feelings about things, you have a problem. You don't want my feelings, right? You want my skills to solve a problem for you. And even with clients, when I ended up, I did a lot of government work, and I was representing, these sort of abstract government agencies, government officials in cases. And I remember thinking, look, they want my skills. They don't want my sort of intense feelings about something. They want me to go in and explain 1, 2, 3. This is why my client ought to prevail. There's a sort of formalism about it. And that was always very comfortable for me. What I've seen from law students, and again, it's a bad sample set, but what I've seen from law students is this, what the poet would call passionate intensity, right? Yeats. And I see a lot of passionate intensity, and that's not a good thing because it suggests that there's not a lot of reason going on here. And I do worry about that. As I said earlier, if that were a day-to-day part of deciding cases with my colleagues from Carter through Biden and everybody in between, 17 of us, one of my colleagues says it's the largest forced marriage in America. And she or he did not mean that as a good thing. It's like, wow, how did I end up in this, right? Well, you have to get along with each other. And getting along means, okay, I understand where you're coming from. Here's why I don't agree, or here's why I do agree, or here's where we can compromise. That's less that's not an equation that you learn in law school. That's a culture, that's an attitude, that's a whole view of the world and yourself, and what is my place in this? And if we lose that, then, Article 3 is not, the courts will not survive that if that's all we're getting, right? We won't survive it.
Okay, I'm going to try to open up. Professor Ginsburg, you had your hand up.
Yeah, I have a kind of University of Chicago question. And the background is I've been trying to do something like a Calvin report for firms, not law firms, but private companies. I'm not getting a lot of uptake. And that makes me wonder if maybe markets are working here. Imagine that. That, in other words, that there's some segmentation. Your clients feel like either their labor force or their brand requires this kind of segmentation, and there will be segmentation. There'll be conservative firms, there'll be liberal firms. And I guess I'm trying to figure out why at the firm level that's a problem, as long as the federal courts are thankfully insulated from it. Is this really a problem?
So, I mean, I think it is in part because, right now you have a dynamic where, most of the biggest law firms are skewing one way. And so, and I don't think, I look at, polls about the country and the rest, and so I don't think that you can say, I mean, if you want to look at this as an economist, I would say there's like a market failure here. This is weird. It shouldn't be this way. And so I don't think just saying it's a market solution is sufficient in this area. And then I also think, this is where, I don't know, if we really are serious about the idea of a profession, then maybe we ought not to be, and look, I'm an economist by training and, like a Chicago school one at that. But I don't know that in a profession, you ought to be looking for a market clearing solution. I mean, the whole idea of a profession is that you're not profit maximizing the whole time, and that there are certain distinctive characteristics that make it a profession as opposed to a business. And so I think, law firms traditionally have this model which is not, there may be exceptions here or there, but it's generally not like we're the red team law firm and there's a blue team law firm down the street, go there. It is, the highest traditions of the profession, have been traditionally going all the way back to John Adams. We represent unpopular people and we're willing to do that, and that is in the highest tradition of the profession. And you lose that if you have left firms and right firms and the like. And one thing, and now I'm going to have to run to the airport, but I will say this, in terms of solutions and things like that, I mean, I think law schools, to the extent they want to solve this problem as opposed to perpetuate it, I think law schools need to think about who they're holding up as models. Because, a lot of law schools, all they bring in are cause lawyers on one side or the other. That's who they celebrate. That's who they give honorary degrees to. They don't bring in and give an honorary degree to Lisa, who deserves one. She's like an American icon. She's argued more Supreme Court cases than any woman in American history. And she's represented tobacco companies and people trying to take dog toys away from dogs. She's represented some unpopular clients, and she's done an excellent job. And she's you couldn't. If you talk to Lisa, you get a sense of kind of what her politics are, but if you look at her client list, you just be confused. And, and they ought to hold up people like Lisa as models and not just people who are champions for a cause. And don't get me wrong, some of my best friends are public interest lawyers, and that is a noble part of the profession. And that's the part of the profession, I think, where you do sort of have the red team and the blue team, and let's let Beckett litigate against Americans United and let's see who wins. But in the rest of in the mainstream big law firms, what they used to call white shoe law firms, and I never really knew what that meant because everybody seemed to be wearing black shoes. But at those law firms, we have to get back to the respect for the profession, and I do think law schools, one thing they could do is, give Lisa an honorary degree and don't just give it to the person that's vindicated some particular social agenda through their lawyering.
Professor Bartlett,
Thank you all.
Safe travels, guys.
Before you leave, I just want to let you know how profoundly I disagree with you and Lisa. So, I'm staying, but in terms of the others who might not walk out on me, I want to say that, this symposium has been a lot, I thought, about diversity of viewpoint, and yet it's interesting how much everybody's agreed on almost everything so far. So, and I actually pretty much agreed with a lot of what I heard so far. I profoundly disagree with Lisa and Paul. I am delighted when I see law firms decide that they're not going to represent the Second Amendment folk, and etc. I've been thrilled to that, and I can say that as a law professor, exactly the kind that Paul doesn't either be invited to speak or probably teach there. I was a cause lawyer and I came to Harvard Law School, and I did rather encourage my students to go out and do cause lawyering of some kind. But I also said to them, and I understand lots of you won't for a variety of reasons, and don't worry, because if you go to those fat cat rich corporate law firms, you can take them over and you can do good, because those are the power institutions of this world, and we actually need them. We can't just rely on NAACP Legal Defense Fund, et cetera. We need to take over these power institutions and have them start fighting for social justice. So another couple of things I want to mention before I stop. I profoundly disagree with this idea that the adversary system works, which the adversary system was defended several times. That's what we were talking in law school. And it obviously doesn't. It works for rich people. It doesn't work for poor people. It works for people who can afford these big law firms or other expensive lawyers, for the most part. And finally, I'm delighted to insult and join with the people insulting the Supreme Court, which I do not think is worthy of respect today, and I don't think we should be teaching respect for this Supreme Court. Thank you.
So I love you. Those were great points. Those were fantastic. I feel like I love my paying clients so I can represent my clients who don't pay, and do a lot of pro bono work in the Supreme Court for criminal defendants, veterans. Certain groups just won't hire me, but I would represent, I have done a lot of anti-tribal stuff. I'd love to represent a tribe. I'd love to represent, abortion group would never hire me. I'd love to take an abortion case. So, go hire me. I'm fine to do it pro bono. You should hope that people like me are learning good skills and are happy to do it. I just don't want to be shamed, and I'm not going to be shamed. I think teaching shame to people is a bad thing. I think it's fine to disagree with the court. I always say we should advocate for court packing just to make them nervous. Like, ooh, they get really scared and they start swinging left when you say those words, court packing. So, I think that's okay. It's the shaming and labeling someone as evil because, either they don't agree with you or, whether it's preferred pronouns or something else. I think there's a big difference between, I argued the cheerleading case and the cousin cheerleading case, and what I said, I was more pro-speech in the ACLU. I think schools should let people say whatever they want up to the point where it's bullying and harassing, and that includes hate speech and offensive speech. And we should teach people to get over it, to learn how to take speech other than it's directed at individual and that's harassing, because then you can't educate. You've got to protect people in that sense. But I don't have a problem with your views. You're great.
Professor Kelly.
I want to follow up on the ode to Article 3 that we've been hearing, and just ask for your observations about the fact that most litigation takes place in the state courts. And many, if not most, I think it's most, state court judges are either elected or they have to be reappointed, reaffirmed by the people. And whether you see a difference between that level of court and the Article 3 judges that you're talking about, that we've mostly been talking about.
I mean, I don't know if you take it. Again, my job is to advocate, and I go straight for the every man, woman on the street, whether that's a justice, a circuit judge, a state court judge, or, a traffic cop when I'm trying to get out of a ticket.
You don't think they feel any less protected than?
I don't care. My job is to make sure I'm trying to get you to agree to vote my way on whatever grounds I can get you to win. Literally, I'm very focused on that win. I don't care if you're appointed or not. I feel like every case you've got to go in that it's up for grabs.
State court judges are less protected than Article 3 judges. That's the whole point of Article 3. I wouldn't want to be an elected judge. When I said Article 3 is a cancel culture insurance, it means I don't have to care what they say in the op-ed pages, and that's the way it should be. I'm not going to tell states how to elect judges. I'm not going to get into that political debate, but I don't think I'm saying anything over the line by saying that state court judges who have to worry about not getting elected because they didn't decide this case a certain way, they're not as insulated as an Article 3 judge. It's just a fact.
Okay, Professor Stressen?
Oh, thank you very much. Another really interesting panel. I was thinking of, I hope that Article 3 judges at least will remain a bastion of freedom for thought and for justice and law as we best construe it. But I think of what I said at the beginning of my remarks in the last panel, that as recently as 2017, the dean of the Yale Law School was sure that law schools were the last bastion for this kind of security, and we see how that's crumbled. So, and we also talked in an even earlier panel today about how tenure in the academic context has not been protection, has not afforded adequate protection against cancellation. So you've got a different kind of tenure under Article 3. I don't want to be a worrywart, but I am concerned about can we stave off, to use your water metaphor, Judge Duncan, can we stave off the rising of the waters there? Let me tell you, one straw in the wind, I know it's not part of the legal system, but there have been reports that moot courts at law school, students are refusing to argue certain positions that they disagree with. And another straw in the wind, I fell in love with, decided that I wanted to be a lawyer when I was a debater in middle school and high school. And I don't know if you know what's been going on there, that the judges there are announcing in advance that they will not entertain certain arguments that you are going to lose if you make this kind of an argument. Worse yet, some of the debates have devolved into, rather than debating the stated proposition, a student will stand up and attack a debater on the other team. They engage in this offense archaeology. They look at tweets and social media posts that their adversaries have posted, and they say, we think we have to debate this proposition. It's much more important to decide that this proponent is a racist. And judges have gone along with that. So if you haven't been following this, I urge you to be. You've got to take some protective action so the lawyers don't run.
So it's Nadine, right?
Yes.
So this is perfect. This is exactly what I'm talking about. This is not it doesn't, when I talk about my colleagues on the Fifth Circuit, we have to listen to each other and give reasons. That doesn't mean I'm always going to agree with my colleagues. And they're not going to always agree with me, but the function, what we're doing is giving reasons to each other that may or may not be persuasive, that are grounded in something real, outside of me and outside of you. A student who won't debate, or a judge who won't debate a particular proposition is not a debater. Just like a lawyer, I know, but unfortunately the choir evidently is getting smaller and smaller. A lawyer, and I feel very strongly about this. I totally defend anybody's view that I'm an idiot and I'm wrong and I'm stupid and I should be on the court. Awesome, fantastic. More power to you. More power to you. But when somebody says, I can't even come in and defend a proposition that's an issue in a case, guess what? You're not a lawyer anymore. You are an axe-grinding activist, and you don't belong in a court. It's not an argument. Well, they shouldn't be able to get away with that. Look, and I'll just say it here, just flat out. The students at Stanford who did that, okay, I don't care what they do to me, but they don't belong anywhere near a law degree because they're not being trained to be lawyers. And that kind of behavior will not fly in a legal system. And when it does, you won't have a legal system anymore. You'll have something that they had during the French Revolution, okay? That kind of thing. But that's not a legal system.
And I know that you and I have talked with other free speech advocates on both sides when dealing with previous law school dust-ups. As somebody who still sees herself as liberal, there has to be a way to help the left survive and channel frustration and how to change the system in ways, or convince people of the importance of reproductive rights or transgender rights in a way that's going to secure votes and secure real change, and a way to just express outrage. It is not productive to yell at a wonderful judge who you may not like his opinions, but that's just off limits. And you're not learning. My biggest thing, why I spend so much time with Paul, and I think he spends time with me, is we love disagreeing. We love learning from each other. It sharpens his arguments. Paul walks away from all of our arguments saying, oh, I can beat Lisa, so I must be right. And I think, yeah, okay, he got the better of the argument, but I'm not going to change the way I vote. I'm not going to change the way I think. And, and again, I'll just talk about the abortion issue. If Paul's convinced me the problem our side had is all we had was stare decisis. The right has a vision. They've got a philosophy that's consistent. They're right now winning the hearts and minds of people who are into logic, and the left needs to do a better job of doing something other than just saying the court's illegitimate. They need a philosophy and ways of looking at the world that's going to survive reason. And I just think the right will keep winning in the law unless the left comes up with something that's, rhetorically better and more pleasing than, and I do agree that the world is being viewed through the lens of when nobody had the right to vote, but now we got to figure out what to do about it and not just start shaming everyone who's clerking, on the Fifth Circuit.
Professor Duncan, you had a question.
I'm Harvey Zuckman, and I'm an emeritus professor here. I taught First Amendment law, and an issue I never confronted and never probably ever thought about was, where does free expression, protection of free expression, and protection of fair judicial process begin? That question is for the entire panel. I hope someone answers it.
It is, and Professor Kennedy, you also had a question. Since we're running out of time, let's get your question. Okay.
I don't see a tension between free expression and fair judicial process. Maybe I'm misunderstanding the question. We seem to be swimming in an ocean of free speech in this country. My goodness, has speech ever been this free? I mean, as most people's speech, unless you want to say certain things that people don't like. But my goodness, in this country, again, in this country, you can say all kind of stuff about the president, about federal judges, about people in Congress. You can say and speak and Twitter and whatever, Instagram or whatever the heck, all this stuff that I don't have. You can say whatever the heck you want. There are countries, European countries, where if you deny the Holocaust, you're going to jail. Not in this country, at least not yet, right? I don't enjoy it when people say racist or anti-Semitic things. Goodness knows, and we have some examples of that going on right now. Do I enjoy it? Absolutely not. But in our country, we have a very, very, very liberal view of freedom of speech, at least according to the cases that I've read and apply on a daily basis. If I don't want to live in a country where the government can punish you for saying something offensive, I just don't want to live in that country. I don't think I do live in that country. But
when it may affect the judicial process?
How does it, tell me, how do you think it affects the judicial process?
Well, if someone goes public attacking a witness who's about to be called,
Well, I mean, we have
is there a place where that witness may be cowed into not talking, or?
I mean, that is clearly a limit on free speech, and we have rules for that. They just need to be enforced. You can't intimidate witnesses, right?
Is there any more?
Yeah, and I think we can end, I think, on the point that I think Professor Strossen was arguing before, which is what happens though when the judge says, I'm not going to entertain certain arguments. I mean, I've been in cases where you walk in and the judge tells you, we can argue whatever you want, but you're going to lose. And I thought one of the reasons I went into teaching was because it was so frustrating sometimes.
Yeah, I mean, forgive me if I missed, I thought you were talking about it in a debate scenario.
I was, but I'm concerned about the culture creeping in through the law schools, and then those become law clerks, and then they become the judges.
Right.
Yeah, you can, look, I mean, you can argue whatever you want. I mean, there are certain arguments that are foreclosed by precedent that are just not going to fly. But I hear all sorts of arguments all the time.
The Chief Justice rank was once, I forget, it was a lawyer for the state in a case where it was, can you take a battering ram and run it through someone's door without, any cause? And he was arguing for it. The chief says, do you have a fallback position? And the lawyer said, yes. And he goes, I suggest you fall back. And it's like, you gotta love the old chief. He was just saying, you're crazy. Let's go with something else. So I thought that he was trying to help the lawyer out there.
That's right.
I think though you're pointing to something a little bit more insidious than all this, where there's certain arguments that are just sort of viewed as that's just not the kind of thing. Yeah,
Right.
something is not
You
debatable.
can't teach certain things, and we're not able to argue certain things. You're not going to hear certain things. I mean, I think this is our fear. Is it? How do you stop this?
I'm fine, thank you.
And I don't know. This is a cultural thing. How do you stop it?
I don't know. I mean, I come back to what I said earlier about policing language. I'll give you a concrete example. We have plenty of racial discrimination cases in the employment context where somebody is accused of using a racial epithet, okay? And sometimes people act like, I can't even allude to what the racial epithet was. And I say to my clerks and my clients, I'm sorry, the person said something offensive and it's legally actionable. I'm going to say what they said. Not because I want to offend people, but because you should see what people say. What people say is offensive, and that's why it's legally actionable under Title VII. But if we act like we're all of a sudden Victorians, neo-Victorians or something, and there's certain words you don't say, I'm not talking about gratuitous use of racial epithets. I'm talking about this is the actionable statement in the case. Let's be adults. There's a reason it's legally actionable.
You're preaching to the choir, but I know of at least 2 law schools that have adopted absolute rules that you may never say that word. You may not even be able to say a euphemized version of it, even if you are quoting from a court opinion.
Yeah, I've heard that. I just don't understand the psychology behind that. And trust me, it's not a logical thing, it's a psychological thing. It's again, Victorians, it's like we can't talk about women's ankles or whatever they say we couldn't talk about.
It's like, do math, but don't use numbers. I just, that kind of thing.
Yeah.
It's what we're
I don't understand that. And I do try to push back on that. But I'm just one loopy Fifth Circuit judge. What does it matter?
Well, with that, I think we're going to bring the
See, when
panel
Paul
to a
walked in, he
close.
got
I want
really
to thank our speakers and
Thank you.